to Crime in Court. This is episode 90 of the Canton cover-up, Commonwealth versus Karen Reed. And my apologies if you tuned in last night. You may have noticed that I was muted. My OBS system that I use to record decided that it just forgot that I had a mic. So I love when things just change their settings on you. So it is obviously fixed now. So we will proceed with the episode that I wanted last night, because last night was a week in review of the previous week. So as you can see from the title, we're going to go over the motion hearing and we're going to go over some new court filings. So let's get started. Please hit the like button and let's begin. All right, so I said we're going to go over the motion hearing. They had a motion hearing on the 13th, and Adam Lally was there. The new prosecutor, Hank Brennan, was there. The usual people: Alan Jackson, David Yannetti, Liza, was Miss Little there? I can't remember if she was or not. I want to say yes, but I don't remember. Maybe she wasn't. But I know Alan Jackson and David Yannetti were there. Karen, her family. All right, and many supporters. So um, I'm just going to go over the recap. It was relatively short. It's going to take about as much time as I read it as it would to basically go through it. Although if you want to see some spicy stuff, it is kind of interesting to see Judge Canoni get real witchy at the end. So here is my recap. This is from my X page. So Karen Reed, motion hearing 11/13/2024. Karen Reed and her defense team were back in court this morning for a motion hearing. The unprepared special prosecutor, Hank Brennan, failed to subpoena Verizon phone records, thus delaying a motion 17 argument for discovery, which will now take place November 26th. So just to provide reference, we went over in my previous video, we went over the subpoena. They're trying to get a subpoena for Mr. Reed's Verizon records, which we will also learn that they're trying to get Janet Reed's, uh, Bill and Janet Reed's, both of their Verizon records, the parents of Karen Reed, because she spoke to them. So, anyways, that's what they're trying to get. But he failed to subpoena Verizon. He failed to notify them, thus they could not argue the motion 17 hearing, which was like a big point of why they were there on that day. But I digress. So that had to be delayed, and they scheduled a hearing for November 26th. I think it's going to get loud. So Hank Brennan, no, she's not that loud. All right, so Hank Brennan asked to retest Reed's Lexus telematics system. Okay, now everybody's getting loud. Hold on. This is like my third try trying to do this intro because my dogs keep interrupting, and I'm just going to push forward because it's really frustrating to me. So in my last video, Hank Brennan, we went over a motion where he wants to retest um, Karen Reed's Lexus, her telematics system, which she doesn't have an issue with. So they're arguing that all of the information that's there was not gathered the first time. He also argued against allowing a defense expert to be present during the possibly destructive testing. So this test that the Commonwealth wants to proceed with on her Lexus could destroy the data, could destroy the product that they're testing it off of. So once this chip off thing that they're talking about takes place, it could destroy the data. So they want to make sure, the defense obviously wants to make sure that they have a guy that knows what they're doing. And we already know that this guy got bits versus bytes wrong, which was a big deal because if they actually did the right equation into bytes versus bits, whatever it is, they would have figured out that there is no data missing, but this expert that said that there's data missing is the one that doesn't know bytes from bits. So, anyways, and he's the one that's going to do the testing. And so the defense obviously is a little, concerned that this guy might not be really knowing what he's doing. So, anyways, Hank Brennan is pushing for the retest of the Lexus to take place before Thanksgiving. So they want to proceed with that very expeditiously. All right, so the defense attorney, Alan Jackson, fought back by stating that the Commonwealth's new expert, Shannon Burgess, misinterpreted the data and confused bytes and bits, a fundamental concept in digital forensics. Like, this is, math 101 to a digital forensics guy. So they should be able to understand it going in, and, this is not something the average person should misinterpret, because bytes versus bits is something that you should know. Any expert in this should know. All right, so the confusion led Shannon Burgess to believe that data was missing when it was not, according to the defense. So the defense wants their expert to be present and to have the opportunity to halt any testing that might be destructive, and to notify the attorneys on both sides before proceeding. So if he wants to be present, the expert for the defense, who they had to now hire this new expert because of this bits and bytes guy, and so that they could, refute him. And now they want him to be present during the testing, so that if there is a moment where something's going to be destroyed, or he doesn't seem like he knows what he's doing, the defense expert can step in and be like, "Hold on there. Let's talk to the attorneys before that happens, before you do that destructive test." So the defense wants their expert to be present and to have the opportunity to halt any testing that might be destructive, and to notify the attorneys on both sides before proceeding with any destructive kind of testing. So both sides argued in favor of continuing the January 27th trial, moving it to April 1st, as would be necessary to meet discovery obligations with additional testing and these new experts. So we've got all this additional testing that the Commonwealth is trying to do. We've got new experts that the Commonwealth is bringing in, and the defense has new experts too. So we need to have time to do testing, have time to, exchange discovery and things like that. So the defense, and this was a motion, a joint motion between the Commonwealth and the defense. They wanted to move it to April 1st, and Judge Bev said she's going to keep it on the 27th, and remain like everything's happening on the 27th in January. And if we need to change it, we'll change it later, she says. So whatever. She has not ruled on that. So defense again plans to call Dr. Russell. Dr. Marie Russell was the dog bite expert. She was an ER doctor for basically her entire career. I don't know why I said that weird. That came out strange. And then not just has she treated many, many, many dog bites throughout her career in the ER, but she literally wrote a book on dog bites. She's the dog bite expert, and how dog bites and scratches and animal attacks appear on the flesh, the wound. So she's an expert on that. So, but the Commonwealth in their amazing glory, because that they have just the most outstanding experts that don't know their bits from their bites, and say the crime scene talked to them and it just happened that way. These are their experts. Also, their data expert was Trooper Garino, who missed 32,000 text messages from Sandra Birchmore's phone and Matthew Farwell. Between Sandra Birchmore and Matthew Farwell, there were 32,000 text messages that he somehow didn't see. I'm sorry, this hair just I, growing out bangs is like the worst because it's always in my face. And I can't stand it. All right, so the defense plans to call Dr. Russell, but the Commonwealth requested another Daubert hearing. A Daubert hearing is like to determine if your expert is experty enough. Does your expert really qualify as an expert? Do they have the experience, the knowledge, the know-how, the blah, blah, blah? So they did this already. If you recall, during trial, they did a Daubert hearing for Dr. Russell, and she had to go through the process. Pannoni approved her she allowed her to testify, and she did. So I don't know why they're having another Daubert hearing, but here we are. That's what they're requesting. So they're requesting another Daubert hearing to determine the admissibility of her testimony, even though she already went through a Daubert hearing during the first trial. And Judge Cannoni allowed her to testify regarding her opinion and whether Officer O'Keefe's injuries were caused by a dog. Her second Daubert hearing, so now she's got to come back she's got to fly in from wherever she lives, and Karen's got to pay for this, and she's going to testify or go through this Daubert hearing on December 12th. So that is coming up. Judge Bev is allowing counsel to review transcripts of all of the sidebars from the first trial. This was a request from, I think, the defense. I can't remember now. Somebody requested that they be unimpounded, but um, she said to Hank Brennan during the hearing, Judge Cannoni said to him that counsel is allowed to see transcripts even if they're impounded. So he would have, whatever. I don't know why they put a motion forward. Hank Hank Brennan really didn't seem to know like the procedure and the process, and was told multiple times basically to get that from Mr. Lawley, who was also there and didn't say a word. All right, so Judge Bev is allowing counsel to review the transcripts, but she's going to keep them impounded from the public. We cannot see them. So all these sidebar conversations that may have important information to prepare for trial. She did not rule on anything else from the bench. And finally, just because she can't help herself, Bias Bev got extra snippy with Alan Jackson during scheduling. So at this point in time, the hearing's basically over. All they're doing is scheduling their next hearing. And something, she wanted him there on the 10th. And Alan Jackson's like, well, I've got something all day on the 9th, and I can't get here for, a morning meeting session. And so Judge Bev, her response was, a lot of people take a red eye, right? Can you come then? Like, her condescending way. And Jackson responded to her, I do every time. And my comment was she's such an effing bee. Yeah. And I made a nice little image for you guys there on my X page. So that is, in a nutshell, what happened at the hearing. All right, so now we're going to move on to some filings. These all came in like all throughout the week last week. So instead of doing one little video here and there, I wanted to like keep them together. So we're not, I'm not bombarding you with teeny tiny videos. All right, so this one is a little bit longer, but we're going to skip through some of the parts, some of the boring like legal stuff, but we'll get through it. We'll get through the good stuff. All right, so this is the defendants. Everything else from now on after this is going to be from the Commonwealth, just so you know. And you can't see all the tabs I have open. I've got a lot open. So we've got a lot to get through. So I'm going to shut up and get through it. This is the defendant's memorandum in opposition to the Commonwealth's motion pursuant to Rule 17 of the Criminal Procedure directed to Bill Reed's Verizon records. So this is Mr. Reed, Karen's father. So here goes. Now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny the Commonwealth Rule 17 motion for order directed to William Reed and Verizon Wireless. The Commonwealth's motion is a fishing expedition and an inappropriate attempt to invade Mr. Reed's privacy. All plausibly relevant information that the Commonwealth could glean from the requested cellular records is redundant and duplicative of the information already contained in Reed's cellular, telephone, and Verizon records, which have been in the Commonwealth's possession since the start of this case. I'm going to highlight that. It's been in their possession since the start of this case. They have all of the data. I want to repeat. All of the data that they got from Karen, none of it has been altered. None of it's been deleted. None of it's been modified in any way. There aren't any suspicious butt dials. There aren't suspicious, calls, then hang-ups and trying to find, like you're maybe trying to find someone's phone. There's a lot of suspicious things that happened that night, but not on Karen's end. And all of the data that the Commonwealth has, it is the data. It's pure, accurate data that came off of her phone, unadulterated, and there's no reason to believe that there's anything missing or that they would find anything more. And that's basically what they're saying here. So the Commonwealth has utterly failed to demonstrate that any information contained in Mr. Reed's cellular records beyond information that is already in the Commonwealth's possession is relevant to the instant proceeding. The instant request constitutes a thinly veiled attempt to embark on a blind inquiry into Mr. Reed's personal information and cellular data. So again, they're just going in blindly saying, yeah, just give me what you got because I want to see if there's anything that might incriminate Karen. Maybe we'll charge Mr. Reed too, if we can, because that's exactly what they would do. Indeed, to the extent that the Commonwealth seeks records unrelated to Ms. Reed, the request is overbroad and impermissible and invasive violation of Mr. Reed's privacy. For these reasons, the Commonwealth motion should be denied. Factual background. On October 18th, 2024, the Commonwealth filed a motion pursuant to Rule 17 requesting Verizon records for, inter alia, among other things, customer data and personal information associated with Mr. Reed's cell phone. Mr. Reed is Ms. Reed's father. Mr. Reed was not present at C.F. McCarthy's The Waterfall Bar and Grill or 34 Fairview Road in Canton, Massachusetts on the days of January 28th or 29th. How about you go get the phones from the people that were present at those locations? Why don't we work on getting those phones first? Oh, wait. Brian Albert and Brian Higgins already went and threw their phones away or got rid of them. Like, who throws phones away anyways? Usually you turn them in and recycle them so you get, well, whatever. They were thrown away so that any evidence could not be tracked back to them. But not Mr. Reed, not Karen Reed, not Janet Reed, the other Mrs. Reed, or Mrs. Reed, I guess she's Mrs. Reed. Yeah, so none of them got rid of their phones. None of them went to army bases or military bases to take their SIM card out and destroy them and throw them in different garbage bins, which seems excessive if you're not trying to hide something. Just saying. So Mr. Reed is not a witness to any of the relevant issues involved in this case and was not called by the Commonwealth to testify in the initial trial of this matter. Based on the showing set forth in the Commonwealth's papers, it appears that they are seeking communications between Mr. Reed and his daughter between, get this, December 30th, 2021 through January 30th, 2022. So they are they're trying to get a whole month's worth of data of their communications, and these are days prior to the crime. So it doesn't make any sense why they're going a month prior, but let's see. All right, so however, all of the communications at issue are already in the possession of the Commonwealth because whatever communication she had with Mr. Reed, it would have been on Karen's phone, which they have. They haven't proven any that it's really on the state to say, well, we have reason to believe, and here's why we believe this, that they were communicating on December 30th about taking John's life or something. Like they would have to have some kind of good faith showing as to, well, we have reason to believe because blah, blah, blah. But that's obviously not the case, and I was just making that up. All right, so Mr. Reed is not a witness. And they want all of that month's worth of data. So, indeed, Trooper Proctor seized Ms. Reed's cell phone on the afternoon of January 29th, 2022, the very day that they found John. Ms. Reed's phone was subsequently searched by the Massachusetts State Police pursuant to a search warrant issued on February 2nd, 2022. February 2nd search warrant for Karen Reed's cell phone is attached, but we're not going to look through it. All right, so thus, the Commonwealth has in its possession a full extraction of Ms. Reed's cell phone. So they already have it. This extraction, obtained from Ms. Reed's cell phone, includes all calls between Ms. Reed and her father on January 29th and all calls exchanged between Ms. Reed and her father in the month preceding that date. Moreover, on December 7th, 2022, the Massachusetts State Police obtained Ms. Reed's personal cell phone records from Verizon pursuant to a search warrant for the period of 12 a.m. on January 29th to approximately 7 a.m. on January 29th, including the following information: subscriber records, specialized location records, call, text, data, detail records, time on tower and or sector, electronically stored records, and carrier key. Got another footnote here. The search warrant for her phone is attached, but we're not going to see that. All right. Where was I? There are no inconsistencies between the data extracted from Ms. Reed's cell phone and the data from Verizon's carrier side call and text records. So, no discrepancies, no inconsistencies. It is the same, much like the data that was collected from the original telematics chip off that they're saying they didn't get all the data. It is pretty uh, clear that they did. In other words, nothing from Ms. Reed's phone was deleted or altered in any way from the time electronic communications were made to the time that the state police collected her records. This is particularly noteworthy in this instance, given the same cannot be said of other parties present at 34 Fairview Road, as I pointed out earlier. All right, so Ms. Reed's father, William Reed, has never been called by the Commonwealth to testify as a witness in this case. Now, 3 years later, the Commonwealth seeks to invade Mr. Reed's privacy by obtaining all of his call and text records for an entire month prior to January 29th. The Commonwealth seeks the following records from Mr. Reed and his cell phone provider. So, number one, subscriber information associated with Mr. Reed's phone number. Number two, records from all Verizon transactions, including all call records, call detail records, SMS and MMS text records, and all data use records associated with Mr. Reed's phone number for the period of January 29th through January 30th, and records for all call records and call detail records for the period of December 30th through January 30th. Again, there's that month-long period of what they want. What exactly are they looking for? Like, that is exactly a fishing expedition. You have to be really narrow on your search warrants, especially when it comes to data, because privacy. And, you can't just willy-nilly give out search warrants as a judge just for no reason. So, you have to have a reason to actually look for that. And it should be narrowly tailored, not, this month's worth of time just because we think they may have communicated about something. They didn't even say that they think that they've talked during that time, but whatever. All right, so in support of this overbroad request, the Commonwealth makes several references to Ms. Reed's cell phone data, which is obtained via the aforementioned search warrants. The Commonwealth states that in the aftermath of Ms. Reed being unable to get in touch with Mr. O'Keefe in the early hours of January 29th, Ms. Reed made several phone calls, including to William and Janet Reed, her parents. The Commonwealth goes on to explain how they plan to call Mr. Reed as a witness in the upcoming trial to question him about conflicting statements made by Ms. Reed on January 29th. All right. So, at best, I'm sighing because I'm just so sick of the Commonwealth pulling their BS. Commonwealth's request is an overbroad fishing expedition. At worst, it is an attempt to harass Ms. Reed's family. In its Rule 17 motion, the Commonwealth states that Ms. Reed had three phones to her mother, three phone calls, sorry. She made three phone calls to her mother from 1:14 a.m., 4:38 a.m., and 4:42 a.m. on January 29th. Notably, none of these calls were answered. So, she may have made some calls, but they went unanswered. Ms. Reed did not make any calls to her father, Mr. Reed, on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn at 34 Fairview Road at 6:30 is when she called her dad. Commonwealth is able to reference all of this information because they are already in receipt of Ms. Reed's phone records confirming the same. As set forth herein, the Commonwealth has failed to establish good cause for its request to invade Mr. Reed's privacy interests and search his phone for irrelevant information under Lampron. Lampron is the criteria used for such a thing. So, we're not going to go through all the legal arguments here, but I'll read bits and pieces here. So the first argument is legal landscape and evidentiary standard. When a party moves the court to subpoena documents in advance of trial, the burden is on the moving party to establish good cause for the court to grant the motion. And they use this Commonwealth versus Lampron as their criteria. So here's their criteria. Number 1, that the documents are evidentiary and relevant. Number 2, that the documents are not otherwise procurable reasonably in advance of trial by exercise of due diligence, because he's probably not going to just hand them over. And 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend to unreasonably delay the trial. And 4, that the application is made in good faith and is not intended as a general fishing expedition, which I have circled real big because I believe this is a fishing expedition. They do say in one of their motions, which we'll read later, that they want to look at the patterns of how frequently Karen calls her dad and mom at night at those hours. But my argument there is that those nights, John came home. She wasn't worried about him coming home that night. So it's really not a good argument to say, well, she doesn't call them every night at 4 in the morning because she was going through a crisis at the time. So I don't think that that's a good excuse as to why they should go and look through Mr. Reed's cell phone records for a full month. The moving party bears the burden to set forth with particularity some factual basis. All right, I'm not going to read all this, but basically, you get the gist. So they really have to put forth, and they have to meet all of those prongs. And as you can see, they really don't. All right. So the Commonwealth has failed to meet the requirements necessary to satisfy the Lampron standard to compel production of the requested documents. The Commonwealth's request for Mr. Reed's cell records fails to satisfy all four of the necessary elements required under Lampron. The Lampron requirements are conjunctive. If the movement fails to satisfy any one of the four requirements, the court must deny the motion. Next, the requested records are not evidentiary and relevant, and they go on and explain why they're not for everything. So, I'm going to read through all of it here. Their next point is the requested records are otherwise procurable in advance of trial with reasonable due diligence. Lampron also requires that the Commonwealth show that the requested documents are not otherwise procurable reasonably in advance of the trial. The Commonwealth has failed to make that showing here. All of the information requested by the Commonwealth is already in its possession. In fact, the Commonwealth has been in the possession of Ms. Reed's entire call history for more than 2 years. I think that's a great point to make. The Commonwealth has access to all information contained within Ms. Reed's phone from the time that it was activated through the date it was seized. The Commonwealth has never raised concerns about the authenticity of the information contained in Ms. Reed's cell phones or cell records. In fact, they relied on those records repeatedly throughout the initial trial in this matter. Had the Commonwealth exercised reasonable due diligence in advance of filing its Rule 17 motion, it would be apparent that the Commonwealth is already in possession of the requested information. Therefore, because the Commonwealth has already procured the requested information, its motion should be denied. Their next point is the Commonwealth can effectively prepare for trial without the requested information. Commonwealth's failure to obtain the requested records will not unreasonably delay the trial because the Commonwealth is already in possession of the information it seeks from two different sources. Cellbrite analysis conducted by the Office of the Attorney General of Ms. Reed's personal cell phone and Verizon records. Any records of calls from Ms. Reed and or cell phone carrier will merely constitute a third copy of the communications between her and Mr. Reed and his daughter. Commonwealth does not need to invade Mr. Reed's privacy in order to prepare for trial. As such, it should be denied. Their next point, the instant request is not made in good faith and is an inappropriate fishing expedition. The Commonwealth's request is not made in good faith, is not narrowly construed, and appears to be a fishing expedition to sift through Mr. Reed's cell phone records for potential evidence unrelated to his communications with Ms. Reed. The court has repeatedly emphasized over the course of these proceedings that the Rule 17 is not a discovery tool. Those are Judge Canoni's words being used in this filing. So we'll see how that goes. I love it when an attorney can throw words back into a judge's face. I mean, not like they're like na 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 boo boo, but kind of because it's like, well, you already said this, so you can't back out of what you said because you said it here. So how does it not apply here? So they do that twice in here where they really get her. All right, so Rule 17 is not invoked merely for the exploration of potential evidence. The duplicative nature of the records sought exposes the Commonwealth's true intentions. If the Commonwealth had alternative reasons for seeking Mr. Reed's cell records above and beyond any calls or text messages with his daughter, those reasons were not set forth in the motion's supporting affidavit. There is simply no reasonable justification for the Commonwealth seeking all of Mr. Reed's call records for a month without any limitation whatsoever as to the recipient of those calls. The court must balance the Commonwealth's right to receive relevant information with unwarranted harassment of witnesses and third parties. As this court acknowledges, so this is again using Judge Cannoni's words and throwing it in her face again, as this court has acknowledged, electronic devices are repositories of a vast store of sensitive information that can provide an intimate window into a person's life. Therefore, you don't want to breach that sense of privacy for citizens, for witnesses and third parties. They're not on trial here, so you don't need to be subpoenaing their phone records and invading their total privacy. So finally, with respect to the requested time period, the Commonwealth's request is overbroad in its request for all call and text records from January 29th through the 30th, and the Commonwealth claims that these records are limited to the immediate time and aftermath of the alleged crime and document the relevant interactions between the parties. If you noticed in Karen Reed's subpoena, we read it earlier, it was only for like this time to this time. Because again, you don't want to be doing these like broad ranges. So they only got a subpoena for her phone from, 12 o'clock at night to, or whatever time at night to 6:30 in the morning after John was found. So they're not going to be, or well, when it was handed over, not when it was found, but they still, they only have it. They can only look at so much. And they might be able to extract the entire thing, but that doesn't mean that they should be going and looking through medical records and record, or, emails to your lawyer, things like that. There's still privileged information on there. So that's why they need to be specific on what they believe they're going to find. So the Commonwealth has failed to allege any particularized facts in its affidavit suggesting why it believes relevant information will be obtained from Mr. Reed's phone on January 30th. The Commonwealth has not listed with particularity any facts of import that took place on January 30th. So why are they looking for his phone? What's the reason? What do you think you're going to find? Is there a reason you think that? You can't just go fishing. In fact, the basis for the instant request is that the Commonwealth believes Ms. Reed and her father were communicating before Ms. Reed was in the hospital at approximately 7:30 a.m. The Commonwealth has presented no basis whatsoever demonstrating the necessity of obtaining Mr. Reed's cell records from January 30th. Thus, this request should be denied. Finally, the Commonwealth's claims to have made an effort to best protect William Reed's privacy rights by limiting its request to all of Mr. Reed's call data from December 30th through January 30th. That they think that's a limit, that's a good thing. However, the Commonwealth's request is not narrowly tailored at all. The instant request appears to be a blatant attempt to fish for salacious information unknown to the Commonwealth, impermissibly seek discovery, violate Mr. Reed's privacy, and intimidate the Reed family by sending the message that their lives are subject to inspection by the Commonwealth. God, I love how they write, whoever does their stuff. This was either Alan Jackson or David Yannetti. They both signed it, and they say this should be denied. Obviously, they don't want that to be approved or allowed by Judge Cannoni. All right, so next, after that, we just find out that they are all also asking for Janet Reed's cell phone from Verizon Wireless. So Janet is Karen's mother. So now comes the Commonwealth and respectfully requests this honorable court, pursuant to Mass R. Crim P. 17 and Commonwealth versus Lampron, issue a court order to Verizon ordering the keeper of records of Verizon Wireless to produce to the criminal clerk's office of the Norfolk Superior Court one, subscriber information associated with the Verizon number that's redacted from December 30th to January 30th. Again, that month-long period of time they want. Belonging to Janet Reed of Dighton, Massachusetts, records for all call records and call detail records for the period of December 30th through January 30th. In support of its motion, the Commonwealth states the following. On June 9th, 2022, the defendant is indicted by the Norfolk Grand Jury for second-degree homicide in violation of that statute, manslaughter while operating under the influence and leaving the scene of personal injury or loss of life. On January 29th, the Commonwealth alleges that the defendant struck the defendant. That's exactly what they said. The defendant struck the defendant with her car and caused his loss of life. The defendant returned to the victim's home after striking the victim with her vehicle and leaving him incapacitated in blizzard conditions. Through the evening and morning of the victim's loss of life, as it was happening, the defendant made numerous calls to various people providing varying and conflicting statements about the whereabouts of the victim. But I want to say that those varying complaints or varying things that Karen said on those phone calls early in the morning have never been proven to have been said. She's never admitted that she said them. She's never said that in any interview. It's only coming from hearsay, from word of mouth, from Carrie Roberts and from Jennifer McCabe. And who knows what their story is now from what the truth was, because, their story seems to change a lot. So I don't put a whole lot of weight into it. Anyways, all right. So, where did I leave off? All right. They want all the calls. Commonwealth intends on calling William Reed as a witness to testify to some of the various admissions made by the defendant. So now they want to call Mr. Reed to the stand. So ridiculous. Specifically, in the Boston 25 News aired segment, reporter Ted Daniel asks William Reed, did your first discussion with Karen, did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? That was in the hospital. She says, I remember, all right, backing up and hitting something. That doesn't mean she hit him. That was at the hospital. Okay. So contrary to that account, the defendant's first discussion with William Reed was not when she was in the hospital. Rather, the first conversation occurred before the defendant was transported from the crime scene. The defendant's phone records also detail her outgoing unanswered phone calls to her mother. So again, they were unanswered. So what difference does it make that she called her at those times? And then all three unanswered occurred after the defendant left John O'Keefe and before John O'Keefe was found. Yeah, it's after she left him at 34 Fairview Road, alive and well, and then she went home and made some calls because she was worried about John and wanted advice from her parents. Who cares? William Reed and the defendant conducted their first call at 6:32 a.m., which lasted 3 minutes and 51 seconds. Medical records note that Karen Reed was admitted to the hospital at 7:26. I also want to come out and say, because there's people stated as fact that Karen's dad is the one that called it in and said that she was going to take her life, or she was saying that she wanted to not live or whatever. But that's never been proven or confirmed. I don't know if that's anywhere that's ever been proven or confirmed that he was actually the one that sectioned her. I I kind of feel like it was maybe an afterthought after she left the scene, and then the officers that were in on the cover up were like, "Oh yeah, by the way, maybe we should section her and get her blood alcohol." That's what I think happened. All right, so William Reed and the defendant conducted their first phone call, 6:30, lasted 3 minutes and 51 seconds. Medical records note Karen was admitted at 7:26. The Commonwealth seeks the phone records of Janet Reed in two separate areas. One, subscriber information associated with the Verizon phone number that's redacted belonging to her, and also records for all call records and call detail records for the period of December 30th through January 30th. Janet Reed's phone records must be made available to use as potential impeachment evidence, depending on the testimony of William Reed. The time scope of this request extends 30 days prior to the evening of alleged criminal activity. However, the content of the request is appropriately narrow. Yeah, okay. And strictly limited to what is relevant. This limited request is made to best protect Janet Reed's privacy while allowing evidence to compare the timing and frequency of Karen Reed's calls to her mother on the night of the victim's homicide as compared to the frequency or lack thereof on dates not involving this alleged crime. I imagine we're going to see a very similar this opposition that they wrote uh, for Mr. Reed's phone. They're going to probably do the same for Miss Reed's phone. Mrs. Reed's phone. All right, so the defendant's knowledge that she struck Mr. O'Keefe is relevant to the charges. The defendant's abhorrent conduct soon after the Commonwealth alleges she struck Mr. O'Keefe with her vehicle is in inference of her knowledge that she struck him. Timing of and whatever. Okay, so the timing of the defendant's knowledge is also relevant and material in the determination of whether life-saving measures could have saved Mr. O'Keefe's life. Janet Reed's phone records are material and relevant to demonstrate the regularity or irregularity of the defendant's regular communications with the mother in the late hours. That's one way to put it. The regularity or irregularity of the defendant's regular communication. They just want to know how often she calls her mom at 1, 2, 3 in the morning, just to prove, like, oh, well, obviously she's guilty because she called her mom at 4 in the morning that night. Whatever. All right, so the records would be unattainable during trial or would cause a significant delay in trial. No, they wouldn't. And prudent preparation requires acquisition of the records. Why? Why? You're not giving a reason. You're just saying it would. The records are not otherwise procurable reasonably in advance of trial as they are not held in care, custody, or control of the Commonwealth or the defendant, and the entity will not produce the records without a court order. That's why you want them. That's why you want this order, because they won't give it to you without one, and you're kind of screwed because you don't fit the Lampron requirements. But this is Judge Bev, so who knows? The Commonwealth cannot properly prepare for trial without such production and inspection in advance of trial, and the failure to obtain such inspection may tend unreasonably to delay the trial. Sure. Sure there, buddy. Hank, old pal. An affidavit in support of this motion is attached, and for these reasons, it should be allowed. Whatever. I disagree that they should be going after Ms. Reed's cell phone or Mr. Reed's cell phone for that matter. Just ridiculous. It's like, when is this tyranny going to end in Norfolk County? All right, so their next filing, we'll just keep moving along. Next filing is the Commonwealth's motion for all video recordings, audio recordings, interview notes, emails, text messages, and voicemails of Karen Reed in the possession of WCVB TV, Hearst Television Incorporated, and ABC. That was a long title. Breathe. All right, so there's actually two motions that are like this. This is obviously for WCVB TV, ABC. This is for basically the same thing, but from they're requesting of NBC Boston 10 because, as you know, Karen Reed has done a couple interviews on TV, and the Commonwealth wants all of that. Anytime you speak publicly about this stuff, even if it's, you think that it should be protected, it's not. The government can come after you, even though she didn't say anything bad in any of her interviews, but you know that they're going to try to twist her words because that's what they do. So, and that's what I think they would do if they had Mr. Reed's text messages and Mrs. Reed's text messages and phone whatevers. They might misconstrue things and misinterpret things like they do. So, anyways, let's read through this. It's repetitive, so I'm not going to read through all of it for both of them, but just letting you know there's two motions that are basically the same. They're asking for all of the interviews, recordings, notes, blah, 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 from when she was a guest on their show. So now comes the Commonwealth and respectfully requests this honorable court, pursuant to Massar Crim P 17 and Commonwealth versus Lampron, issue a court order to the American Broadcasting Companies, Inc., Hearst Television Incorporated, and WCBB TV, ordering the keeper of the records of each entity to produce to the criminal clerk's office of Norfolk Superior Court the following: the complete video and audio record of all interviews between the defendant and ABC News correspondent Matt Gutman, including but not limited to all raw video footage that was not aired. All handwritten notes of any conversation between Matt Gutman or any ABC News producer, reporter, or editor and the defendant, including but not limiting to off the record or redacted, edited portions of the defendant's statement. So they want anything that may have been redacted, anything that wasn't aired, all of it, which I think is just BS. All right, so all email, sorry, I just have a dry throat. All emails between the defendant and representatives from ABC News, all text messages between the defendant and representatives from ABC News, and all voicemail messages between the defendant and any representative, you guessed it, from ABC News. The sought after information is evidentiary and relevant, cannot be obtained reasonably in advance of trial without this court order, and is being done so as not to unreasonably delay the trial. Lastly, the application is being made in good faith and is not a fishing expedition. On September 1st, 2023, the Commonwealth filed something called DK 19, Commonwealth's Motion for Records, ABC News. The Commonwealth provided ABC News's New York office address. The Commonwealth reported it was unable to properly serve notice to ABC News in New York. On October 11th, 2023, the court denied the Commonwealth's motion without prejudice, ruling that the Commonwealth must comply with the Uniform Act to secure the attendance of witnesses from without a state in criminal proceeding. I don't know what any of that meant. The court's decision reflects that the court order pertains to DK 119 and DK 126. Undersigned counsel believes the court order was meant to apply to DK 119 and DK 122. All right. Well, thank you for that little mix up. DK 19 is a subject that's of a similar nature, but separate motion filed by the Commonwealth. Okay. The Commonwealth intends to legally serve the ABC companies through its registered agent and its affiliate in Massachusetts. And then it talks about jurisdiction, just basically saying it intends to do this, that, and the other, serving these people. Further, WCBB is a television station in Needham, all that stuff. Um, and then what Hearst Television is. So We don't need to know all of that. They do Nightline. Sorry, this was the Nightline 2020 episode, I think, with Karen Reed in it. So the argument here, the defendant's statements to Matt Gutman were initially aired in a 9-minute and 37-second segment on the ABC News show Nightline and broadcasted on WCVB TV to a local audience on August 22nd, 2023. In that segment, the defendant appears in a blue dress seated in a conference room across from Matt Gutman. In this interview, the defendant makes several admissions. Ooh, admissions. Further, she makes statements that conflict with other versions that she has provided to national audiences. No, she doesn't. For example, the defendant asserted to Mr. Gutman, I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy, so I drop him off. He goes up the driveway and approaches the side door, and as I see him approach the door, I look down at my phone. In her 6/20/23 interview with Gretchen Voss, who they also try to get her notes and records from when she did her interview with Karen Reed back then. So in that interview, the defendant's claims are different than her assertion to Matt Gutman. And let's see how different they are. Here's what she said to Ms. Voss. So I pull right up to the foot of the driveway. So far, the same. So I'm parallel to the house. John gets out of the passenger side. Same. He doesn't have a coat on. Same. It's snowing. Okay. And he kind of half skips, runs up to the breezeway door. Okay, this gives a little more detail than what we had. The area connecting to the main house, to the garage, and John opens the door and starts to cross the threshold. So, how is that different than this? The only thing that's different is that she tells you that she picked up her phone right when he approached the home. But just because she left that out in this part doesn't mean that it didn't happen. And I think she gives more detail in this quote here. Anyways, but they don't conflict with one another, so I don't know what the hell he's talking about. They conflict with one another. So both her 6/20/23 version to Voss and Nightline claims to Gutman are in stark discord with her Dateline version. So now here's Dateline. Question: Goes to the front door of the house? Yes. Did you see him go in the house? Yeah, I saw him approach the front door and put his hand on the door. In your memories, going towards the friend's house, how far do you see him go? I see him go to the door and start to cross the threshold, and I'm thinking, all right, I look at my phone. I know you don't see the door open, you don't see him greeted or going in. I see him open the door and put his head inside, and I'm like, all right, he is going to yell to me or come and get me. And I look down at my phone, and in a matter of seconds, I look up and he's not there, and I waited from him to emerge, waited for him to emerge. I don't see how this is different. Again, it's like giving different details, giving more of an explanation, giving context, but it's not incongruent, as his word is here. All three versions are incongruent with the defendant's newly released proclamations in a Vanity Fair magazine. Okay. In the Vanity Fair promotion, the person that wrote the article summarizes. She wondered whether she had dropped her boyfriend off at the wrong house, and after a night of drinking, O'Keefe entered an aggressive stranger's home. She can't wonder that, and also, plus there's no context as to when she wondered that. But anyways, um, she she can wonder that and still have the experience that she already just described. So I don't see how that's different. But okay, and continuing on. Another relevant example is apparent from her Nightline interview where she says, we had an argument on New Year's Eve when we were away on vacation and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew, with his niece and nephew, period. John didn't come back to our room until after 3 a.m. That was rough, and I felt very much taken advantage of, as you probably remember, this is the night of the Aruba girls, Sullivan girls, that one of the Sullivan sisters, Laura Sullivan, or I don't remember this other Sullivan, I can't think of it. Um, Anyways, so the single Sullivan sister, um, well, actually, I think they're both single. I don't know. Anyways, one of the sisters, the one with the dark hair, I can't remember her name for whatever reason. She was Mariana Sullivan, something like that. I don't know. Uh, Stop trying, Heather. She was the one that was allegedly, hugging John, but according to, people that know about it, John and others who described it, John was pretty much like out of his mind, obliterated, and leaning on her and all over her. And oh yeah, by the way, they were kissing too. So, but they deny that. Marietta? Is it Marietta Sullivan? I think that's it. Ms. Reed's reaction to an alleged intoxicated Mr. O'Keefe failing to return to her on New Year's Eve does not reconcile with her frantic reaction on the evening of her collision. On the night Mr. O'Keefe was struck and his life was taken, the defendant engaged in numerous frenzied acts, including calling her mother, her father, calling friends of Mr. O'Keefe, and multiple claims, including opinions that a snowplow had struck him. Again, we don't know that. We don't know that she said that. That was coming from either Carrie Roberts or Jen McCabe, and basically they're the same because Jen McCabe is in Carrie Roberts' ear. So whatever Carrie Roberts says, I feel like is coming from Jen McCabe anyways. And this again doesn't prove anything. Like John was not coming home, so it's okay that she was calling people trying to find him. I don't understand why that's like you're guilty. That's what that means to the Commonwealth, but Commonwealth doesn't think like the rest of us, apparently. So WCVB televised a separate but similar episode via a 2020 program. The 2020 episode was locally broadcasted and promoted by WCVB. The 2020 episode featured the defendant in the same dress and in the same conference room as the Nightline episode, seated across from Matt Gutman. However, the 2020 interview that was broadcast after trial does not incorporate all the defendant's previously broadcasted statements. Noticeably absent from the post trial 2020 episode is the defendant's admission that she thought she may have unwittingly hit the victim and incapacitated him. What I thought could have happened was that did I incapacitate him unwittingly somehow and then in his drunkenness passed out? The defendant's statements are not hearsay and are instead substantive evidence. When a defendant has fully immersed herself in a public relations campaign to promote her versions to the public, she runs the risk that statements may not be beneficial and may be incriminatory. True. But it doesn't mean that she did anything wrong. It's just that the Commonwealth is spinning her words and making it look like she's guilty when she's not. There is no recognized reporter privilege in Massachusetts, which is a shame. It is well settled that news reporters do not have a constitutionally based testimonial privilege that other citizens do not have. There's this whole petition for this promulgation of rules. I'm not even going to read all that because it's very law-y. There's a lot of law in there. All right, so they describe it basically all the reasons why. All right, so there's nothing confidential about the defendant's media interviews with Matt Gutman or any other reporters, producers, or editors affiliated with ABC. The defendant's efforts have been directed, open, and notorious. So she's notorious. The defense strategy is the antithesis of statements provided in the context of confidentiality. The defendant and her counsel cannot avail themselves of a media strategy to publicize and promote the defendant's claims to the public at large and the potential jury pool while simultaneously exercising statements and admissions that are not favorable to her cause. There is no damage to the free flow of information by allowing the Commonwealth's requests because it is the defendant who provided the information to the news sources. The Commonwealth has not sought any information from any confidential source of WCVB, the Hearst television station, or ABC, but only information provided by the defendant's team and the defendant herself. Commonwealth respectfully requests that this court allow the Commonwealth's motion. An affidavit in support is attached. For these reasons, it should be allowed. All right, so basically similar, same arguments for this Dennis Murphy guy who is with NBC Boston 10. She did a interview with him. So they're asking for all the unaired footage, the off-air or off-the-record stuff. They're saying it's all, it meets all four of the prongs for Lampron, which it does not, as we looked at already. Procedural history. The Commonwealth unsuccessfully sought to serve NBCU at its New York office address. The court denied the Commonwealth's motion without prejudice, ruling that the Commonwealth must comply with the Uniform Act to secure the attendance of witnesses. Okay, whatever. The Commonwealth now seeks these materials from NBC 10 Boston, a television station in Needham, Massachusetts that is owned and operated by NBC Television Networks. The Commonwealth now seeks similar materials to DK 122. The Commonwealth intends to provide service to NBCU News local affiliate, NBC Boston. NBC Boston conducts business within the Commonwealth to exclusively distribute NBC Universal content, including Dateline. So that's where they come in. Dateline. She was on Dateline. So they episode a 2-hour episode entitled "The Night of the Nor'easter," which featured interviews with the defendant, her family, and defense counsels. Prior to this episode, reporters and a panelist for NBC 10 Boston discusses on their program Canton Confidential an exclusive preview of the Dateline episode. The argument, they say it is likely that the defendant has made relevant and material statements. Again, I want to point out you have to have a reason for it. Like you have to be like, well, we have a reason to believe that she said more about the taillight off the record because of X, Y, and Z. And here's why we think this. So you can't just say, well, we want all the notes and everything just because we think it's likely that the defendant made some kind of relevant statement. But we'll see. We'll see how this goes because as I was saying in the earlier one, Gretchen Voss, who's another local, I don't even know what she is, if she's a reporter, journalist, but she was inserting herself into this case and reporting on it, and she's pretty much she's gone anti-Karen, anti-free Karen Reed people, and she's on the other side. But anyways, originally Karen went to her and did some kind of an interview, and Lolly had asked for, he put in a motion for it, a 17, Rule 17 motion for getting all of that information, but Canoni ruled against it. She also ruled against, so they never got Gretchen Voss's notes on her interview. Judge Canoni also ruled against when Karen Reed was asking for Brian Albert and Brian Higgins' phones and Jennifer McCabe's phones. They were all denied by Judge Canoni. They had to go to the Superior Court to appeal that so that they could get the phone records of the actual people that were there. However, FYI, Brian, they got rid of their phones the day right before they were going to receive in order not to destroy evidence, which if they had gotten it, or destroyed the phone that day, then it would have been illegal. But now, because it was the day before, it's not. It's obvious what happened there. But anyways, all right. So they're saying it's likely that Karen made these statements that might be relevant. The network's production and airing of its program does not include all the defendant's statements, blah, blah, blah. So here's one. In its promo clip, the network released the defendant's confession saying, this is a confession saying, I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out? And in his drunkenness and in the cold, he didn't come to again. So then this part I have highlighted is the question. Didn't, they forgot to separate it out. So the next thing is, the next question is, this would have been the moment you dropped him off at the party? She says, yeah, would have had to have been. All right, so the promo clip, that's the clip, admitting the defendant believed Mr. O'Keefe didn't look mortally wounded when she dropped him off, is not of the, not when she dropped him off, when she found him, he didn't look mortally wounded. So they're already saying that, like, out of context. Instead, the following exchange is actually broadcast. So the thing before was just in their promo clip. This is what they actually broadcast during the show. Karen Reed says, I said, could I have hit him? Did I hit him? Question, how could that have been? She says, I don't know what else could have been. I thought, did he somehow try to flag me down and maybe trip and I ran over his foot? Then he passed out drunk. I mean, I didn't think I hit him. I didn't think I hit him. Yeah. Okay. Commonwealth is entitled to all statements, admissions, and confessions made by the defendant. Numerous other examples exist, including but not limited to the references made in the Commonwealth's rule. Like, Karen has no control over how they edited her comments. So if they put it out as a promo in one way and then what gets aired is a little different, that's not on her. That's on them. So maybe you need to just ask them what the original was versus, I don't know. I don't even know if I would allow that as a judge, but we'll see. All right. So, what does this say? The Commonwealth is entitled to all those things, demonstrating that the defendant's statements to Dateline that she observed Mr. O'Keefe enter the front door of the Albert home conflicts with many of her other versions. No, it doesn't. The defendant has made tactical and repeated admissions outside the court regarding her activities during the evening of January 28th and the early morning of January 29th. The defendant's statements to Dateline News correspondent Dennis Murphy initially appeared on NBC 10 on July 24th, 2023, during the NBC Universal program Today, where a 2-minute and 33-second preview of a Dateline episode entitled To That Time Taillight Homicide was broadcasted. This segment depicted Karen Reed sitting down for a one-on-one interview with Dateline News correspondent Dennis Murphy 9 months before her first trial. In the preview, she didn't know she was going to have a mistrial. When she agreed to all of these things, they probably said, we won't air them until after your trial. So she thought that her anything that she said probably was not going to be sought after because the shows wouldn't have aired until after the trial. So, but now there was a mistrial and everybody's got the info and they want to get it out, so they're going to put it out there. So, it does kind of hurt her in that regard. In this preview, the defendant discusses her relationship with the victim, denies being intoxicated at the time of the homicide, recounts her initial observations of the deceased victim, and discusses the statements she made at the scene. Following the mistrial on October 18th, a 2-hour episode of Dateline entitled The Night of the Nor'easter aired. The Dateline episode was locally broadcasted and promoted by NBC 10. The episode featured the defendant in the same outfit and in the same room, seated across from Dennis Murphy as she previously appeared in the July 2023 broadcast. Commonwealth has a good faith basis to believe, based on the appearance of the interview, that the full interview with Dennis Murphy occurred before the defendant's first trial, and as such, her statements are highly relevant as they occurred without the hindsight or influence of others' testimony. The defendant's statements are not hearsay and are instead substantive evidence. When a defendant, assisted by her attorneys, deliberately undertakes a public relations campaign and saturates the public with statements likely to reach the potential juror pool, they also run the risk that statements may not be beneficial and be incriminatory. This is all because they want to get back at her for getting out so much information about how corrupt the Norfolk County is. And now they're like, well, you started this war and you started talking about us, so and your case, so we're going to come back at you, and anything you say, we're going to twist your words. The helpfulness or unhelpfulness of the statements does not direct legal basis for disclosure. There is no recognized reporter privilege in Massachusetts. We read that already, so then it becomes very duplicative. I did highlight this for some reason. I don't know why. They were citing another source there, so we don't need to read through all that. There is no damage to the free flow of information by allowing the Commonwealth's request if the defendant who provided it is the defendant who provided the information to the news source. The Commonwealth has not sought any information from any confidential source of NBC 10, Dateline, nor NBC Universal, but only information provided by the defendant's team and the defendant herself. The Commonwealth respectfully requests that this court allow the Commonwealth's motion. An affidavit in support is attached, and for those reasons, this should be allowed. All right, we've got more. I told you guys there's a lot to get through. So, you guys might remember a man named Proctor and how he's under internal affairs investigation. Well, Commonwealth doesn't want that information to come out. So, Commonwealth has filed a motion for protective order for the document from the pending internal affairs investigation. I don't know for sure if this is Michael Proctor, but I have a feeling it's Proctor. We also know Tully he's been rehomed. Buchanan got like 5 vacation days taken away from him. That's a slap on the wrist. But we do know that there are internal affairs investigations going on for probably multiple law enforcement. So, just throwing that out there. We don't know for sure that this is Proctor, but we do know that they also filed a motion to protect Proctor's text messages. So we'll get to that shortly. All right, so the Commonwealth moves pursuant to Mass Crim P 14 that production of a document concerning that is part of a pending internal affairs investigation of a Massachusetts state trooper be limited at this time to the attorney in the case, and that such materials be prohibited from further dissemination. So they only want Karen's attorneys to see these things, and they don't want it getting out. So Karen can't even see these things, just the attorneys. Commonwealth respectfully moves pursuant to the Massachusetts Rules of Criminal Procedure 14 for this honorable court to establish a protective order restricting the public dissemination of a June 26th Massachusetts State Police report concerning a pending internal affairs investigation, which is within the custody of the Commonwealth and therefore subject to Mass Crim P 14, Graham versus DA for Hamden District, and a bunch of others. All right. They basically say, upon a sufficient showing, the judge may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. The judge may alter the time requirements of this rule. The judge may, for cause shown, grant discovery for a defendant on the condition that the material to be discovered be available only to counsel for the defendant. This provision does not alter the allocation of the burden of proof, but with regard to the matter at issue, including privilege. As you can see, it was allowed, and Bev Canoni says no opposition. No opposition. I don't even think that the defense had a chance to look at these, but she approved these or allowed them with no opposition soon after she received them, because this was also dated the 13th. So she didn't even give them a response to respond. She gave them a response to oppose it. The report references potential violations of Massachusetts State Police policy. The referenced internal investigation being conducted by the MSP is ongoing, and MSP counsel has requested a protective order at this time. The issuance of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures and, as a practical matter, to facilitate the discovery necessary for trial. Where the investigation is ongoing, the Commonwealth requests a protective order limiting disclosure to the attorney in this case. Again, not to let Karen Reed see it, and such material shall not be disseminated without prejudice to the defendant's renewal on good cause shown up or change of circumstances. And that was signed by Hank Brennan. Again, it was allowed with no opposition on the 13th, unless he had them written and provided them to counsel that day, and they were like, yeah, we don't oppose. I don't know. All right, so this next motion is Commonwealth's motion for protective order for Trooper Proctor's text messages. So there's more text messages out there that we didn't know about. Just saying, because otherwise, why would you put the protective order? So the text messages that we heard all throughout trial that they read for us, I think there's more text messages than just that. That was just some of it. So the Commonwealth moves pursuant to Mass R. Crim P14 that certain materials being provided as discovery in this case, which may be evidence in an unrelated pending criminal case, be redacted for personal identifying information of minors and unrelated individuals, phone numbers, and for autopsy information, and that dissemination be restricted to defense counsel. As grounds, under Mass R. Crim P, the Commonwealth provided notification regarding testimony by Massachusetts State Police Trooper Michael Proctor in Commonwealth versus Reed, which ended in a mistrial due to the deadlocked jury on July 1st. Commonwealth has provided an official transcript of the trooper's June 10th and June 12th testimony in the Reed matter. The trooper's testimony in Reed included references to prior testimony and text messages obtained as a part of a separate federal proceeding. The parties in Reed received those documents in response to the TUI request for discovery. So again, that TUI request was all of the federal documents that the feds turned over for what they had for the investigation that they thought would be helpful. So the records were only disseminated to the parties in Reed pursuant to a February 20th, 2024 federal court order restricting the recipients from disclosing or disseminating those materials. Contents of the protective order are also covered by the protective order. What? Contents of the protective order are also covered by the protective order. Thus, the Commonwealth cannot produce the contents for in-camera inspection. Okay. On September 24th, oh wait, I missed another one. Then it said see this one. Notice of preservation of evidence upon receipt. So basically they just were given a notice to preserve all of Michael Proctor's text messages. On September 24th, 2024, the Commonwealth received outside of the court order certain partially redacted text messages referenced at trial in the Reed matter. These text chains, however, contain full participant phone numbers and images of minor relatives of a deceased victim and unrelated Facebook friends. Non-parties have a privacy interest in not having their images or their complete cell phone numbers publicly displayed. Some participants in the text chains have been subject to harassment and have a security interest in not having their personal identifying information released, which I agree. You shouldn't be releasing people's personal phone numbers and things like that. So I'm totally cool with redacting certain private information, but when it comes to, stuff relevant to the case, it should not be redacted, in my opinion. All right. So I think it's going to get loud in a minute. All right. So, in addition, while the text messages were discussed at the retrial, the vast majority were marked for identification and impounded. And we have a fourth footnote. During the Reed trial, some text messages were briefly published on a screen, and one set of text messages was admitted as Exhibit 567. All but the last four digits of phone numbers were redacted. Fine, works good. All right. Items entered as exhibits or marked for identification in Reed have been returned to the NDAO, Norfolk District Attorney's Office, in anticipation of the retrial. Reed is scheduled for a retrial on January 27th, 2025, and those text messages could potentially be evidence in the retrial, and disclosure in printed form prior to the retrial could prejudice the parties. Okay. There is also a photograph of the first page of the autopsy report of the victim in Reed, and it would be anticipated that there would be testimony as to the autopsy at the retrial. Upon a sufficient showing, the judge may at any time order the discovery or inspection be denied. This is the same thing we read already in the first one, I believe. Yeah, it's the same thing we read. All right. So accordingly, the Commonwealth requests that it be allowed to redact the images and full phone numbers from the September 24th, 2024 text chains, that dissemination be limited to counsel for the defendant, and that counsels for the defendant not duplicate or provide the text messages to any other person, including but not limited to the defendant. So again, they don't even want Karen to have it, except by leave of the court on a request made on good cause. Commonwealth provided transcripts of the trooper's testimony in Reed, which included reading text messages, so counsel may have full view of the conduct involved. Where dissemination of the actual messages, the first page of the autopsy report, and of cell phone numbers and images not presented at the Reed trial will affect third-party privacy and security interests, blah, blah, blah. And this was also approved or allowed with no opposition, same day by Judge Bev. So what's up with that? I don't know. And finally, we're going to I still have a couple things. We're getting to the end. This is the last filing, really. All right, so the Commonwealth's notice of discovery. So they have to give a notice of what they're going to be using for discovery. So now comes the Commonwealth in the above captioned matter and indicates that of this date, the following discovery materials have been provided to the defendant through defense counsel. Number one, copy of MSP of Office of Professional Integrity and Accountability report. It's a one-page report. Then we've got, another one-pager. Not on my highlighter here. Another one-pager from the same department. Another one-pager from the same department. I wonder if that's the internal affairs stuff, maybe? The Professional Integrity and Accountability Office. Also, we've got a copy of James Crosby's CV. So basically his resume, his curriculum vitae, and it is 11 pages long. Melanie Little talked about him on her stream earlier, I think last week she did. And I believe this is the guy who she looked up. She found him on LinkedIn. She found his LinkedIn page. He's more of like a dog behavioralist specialist, not a dog bite specialist. So this is the guy they're bringing in for like dog bite specialist. But really, he's more on the behavioral side of teaching dogs and working with dogs that are aggressive. So that's, I think, more his angle. So I don't know if he's going to know to identify dog bites, but that's who they got. And apologies, it's so blurry, but copies of engagement letters with James Crosby. Excuse me, with James Crosby. We also got a list of materials sent him because he's got to review things. So everything that was reviewing, they sent him a list of that. Emails, two-page email here dated July 22nd. Another email, 3 pages, October 31st. One-page email dated November 2nd. A one-page email dated November 3rd. And another one-page email dated November 11th, all of this year. A Mansfield Police Department report and a Waltham Police Department report or sheet. But look at the dates on these. They're going back to the year 2000, the millennial, the very beginning of the century. They're going back, and I I think these are police reports or police whatevers that might have Karen's name in them, but that doesn't necessarily mean she's the perpetrator. She could be a victim in these. We have no idea what these police reports are, although I think I heard or saw a Turtle Boy write something on his X page that they're regarding a domestic incident that happened where Karen was actually the victim. So I don't know what that's going to show the Norfolk County or how that's going to help them, but we'll see what they get from records that are 20 years old, 24 years old. All right. Next, we have this is an order. So, up next, I've got a couple orders we're going to read through and then we'll be done. So, we have this is regarding the Lexus telematics system. Upon review and hearing on the Commonwealth's notice for reassembly and additional testing of defendant's Lexus telematics system, it is ordered hereby that testing may occur to acquire the vehicle's data. It is hereby ordered that should the defendant seek to have their own expert present for testing, they provide the Commonwealth the name and contact information of their expert within 5 calendar days. It is so ordered. So she didn't even address anything that has to do with will the defense expert be able to step in and stop some testing from occurring if they want to. So she didn't even address that, but she is saying they have a right to be there. They do have a right to be there. So the Commonwealth can't exclude them. So all they have to do is give the Commonwealth their expert's name within 5 days, not 7, and because they want to make this fast so they can get it done before Thanksgiving. So they're, I'm sure, working on that as we speak. All right, so the last order, the last thing I'm going to read to you is this. So this is regarding, well, they didn't even give us a title, it's just order. So it is hereby ordered that sidebar conferences prior to trial and occurring during the trial that discuss evidentiary issues shall be transcribed and made available to counsel and the court. The court finds that good cause exists to extend the impoundment order for all sidebar conferences that discuss jurors or juror issues. So there you have it. Oh, that was last week in review, basically. And I have another episode that I got to work on because, now I'm behind, really behind. Um, Turtle Boy, in the Turtle Boy case, we've got a new filing, which I've got to read through. So I haven't even had a chance to look at it yet today. So I will get to that in our next video. So stay tuned for episode 91. Let me know what you think of Corrupt Canoni and how she's been handling this situation. What do you think of Hank Brennan? If you watched the hearing at all and you saw him in action, what did you think of him? He was pretty underwhelming, if you ask me, coming from, oh, this big boss prosecutor guy, and then, or no, did he defend Whitey? He defended Whitey. I don't remember. But anyways, yeah. So kind of had like this image that I don't know, he should have been prepared and ready, but he really wasn't. All right. So that is where I will leave you guys. Thank you so much for watching. I really appreciate it. And again, stay tuned for episode 91. I will read to you guys the next latest filing in the Turtle Boy case. So I'll see you then and stay tuned. All right. Please hit the like button on your way out. Thank you guys so much. Take care. Bye now.